Good morning, welcome to the webinar. This webinar is about how to access care during the coronavirus crisis. I'm Julie Stansfield from In Control. This is the third webinar as part of a series that we're hosting for people to share and learn during the crisis. This webinar is going to be recorded so that other people will be able to see it publicly and learn from what we've discussed this morning. And as I've said, this webinar is specifically about accessing care during the crisis. This is how to participate today. Given the amount of attendees, we won't be able to take verbal questions by raising your hands, so we won't be using that today, but we will be using this. There's a question box, and you can type in your question, and we'll do our best to answer as many of those as we can, or Steve will, during the presentation this morning. So I'm going to welcome Steve Broach. Steve, thank you so much for attending this webinar. He's going to give you information on the current legislation. Steve's a barrister at 39 Essex Chambers and has a wide-ranging law experience with a particular focus on the law and policy protecting children and disabled people. I'm just going to hand over the presentation to Steve. Thanks, Steve.
Thank you very much, Julie. I hope everyone can hear me. Good morning, everyone. I'm very pleased to be doing this talk, although I wish I didn't have to, because of course the coronavirus crisis is posing a particular threat to the rights and interests of disabled people and their families and people who care for them. And we have to very quickly get to grips with a changing legal landscape for care provision for both children and adults. And so in the hour that we have today, I'm going to try and cover the key issues around children and adults care. I'm going to look at what the new Coronavirus Act does, in particular to adult continuing health care and adult social care. And I'm going to look at some of the human rights standards that may provide a measure of protection for disabled people and families from suffering from inadequate care or no care at all during the current crisis, although I am concerned that those standards are nowhere near as strong as they should be at the moment. So I did want to start by talking about children, and the key duty to provide social care support to disabled children is Section 2 of the Chronically Sick and Disabled Persons Act 1970, which I hope you can see on your screen. You're now seeing my screen, hopefully. We have the 1970 Act here. If I click on Section 2, we go down to Section 4, and we can see there's a duty on local authorities to provide services to disabled children where they're satisfied that it's necessary for them to meet their needs in order to do so, to provide those services. And the services they have to provide are those listed in subsection 6 and includes essentially all forms of social care support apart from the provision of accommodation. That remains governed by the Children Act 1989, in particular Section 20 of that Act in terms of a duty. But the vast majority of social care support for disabled children will be provided under Section 2 of the 1970 Act. And then of course, for children, there is a national framework for children and young people's continuing care, which deals with the health social care provided for children. However, this is not statutory guidance. It is essentially practice guidance and doesn't have the same force as the adult framework that we're going to see in a moment. And it's not as detailed as the adult framework, and it's not as clear about the split between health and social care as the adult framework. The children's framework describes a three-stage process. We'll see in a moment. First of all, it sets out what continuing care is, essentially a package of additional care for those children and young people with more complex needs, and talks about the transition from the children's to adults framework at 18, saying there are significant differences between the two, and then describes a three-stage process of assessment, decision-making and development of a package of care. But as I said at the beginning, this is all essentially practice guidance. So it's not anywhere near as enforceable as the adult framework. So that's the two highlights I wanted to pick out in terms of the children's framework before we go on. Moving on then to the adults framework, of course, the Care Act from 2014 was the new scheme for adult social care. And before we can look at what the Coronavirus Act does to it, we need to understand the essential elements of the Care Act. So first of all, it starts with a series of general responsibilities, and the one to flag up is Section 1, the wellbeing duty, saying that the general duty of a local authority is to promote individuals' well-being. We then have the definition of well-being whenever they're doing anything under the Care Act. And the definition of well-being includes the individual's personal dignity, including treatment of them with respect, their physical and mental health and emotional well-being, promotion from abuse and neglect, etc., etc. You see the list there at subsection 2. So in everything that local authorities do when they're doing anything under the Care Act, and of course they will still be doing everything under the Care Act even when the Coronavirus Act is in force, they must promote the individual's well-being. And it will be interesting to see what the courts make of that obligation in this very different context if challenges come to court. The attempts to use Section 1 so far, particularly in the Davey case, haven't been very successful, but this will be a different time and we shall see what weight Section 1 will bear in terms of providing a positive obligation on local authorities to promote people's well-being in the way that they carry out their functions. So that's Section 1. Obviously, I'm not going to have time to go through every section. I'll just look at the key provisions. So first of all, the scheme starts with the assessment duties. Section 9 requiring assessments of adult needs for care and support. Section 10 requiring assessments of carers. And then Section 13 establishes the eligibility criteria, which is set out in the regulations, and puts a duty on local authorities to decide whether any of the assessed needs meet the eligibility criteria.
Sorry, Steve, can I just interrupt a minute? There's a lot of people that are not hearing any sound. So I'm just trying to get them to check on their audio settings.
Are some people hearing sound?
Yes, so I'm checking with some people and they're saying, yeah, they can, oh yeah, there's a few coming through saying, yes, I can hear fine. Yes, I can hear it right. Okay, we're on. Sorry, Steve, thank you.
That's fine, Julie. Thanks for checking. So I just mentioned the eligibility criteria, and then jumping forward to arguably the most important section in the Care Act is Section 18, which is the duty to meet needs for care and support. And at the moment, it says that a local authority, having made their eligibility decision, must meet the adult's needs for care and support, which meet the eligibility criteria if they're ordinarily resident in the area, the accrued costs don't exceed the cap on care costs, that's not relevant, and there's no charge under Section 14. So we see that there's quite a clear duty in Section 18 at the moment to meet eligible needs subject to 1 or 2 additional criteria. And that same duty, in essence, also applies to carers' needs for support under Section 20. So that's the specific duty to meet eligible needs established by the Care Act. And if we go back to Section 8, interestingly, the Care Act works very differently than the Chronically Sick and Disabled Persons Act does for children. For children, we saw there was the list of defined services that may have to be provided if they're necessary to meet the child's needs. Whereas for adults, all Section 8 does is give examples, the key word here, of what may be provided to meet needs under Sections 18 to 20. You see some obvious points like accommodation, care and support at home, etc. But those are just examples. And so the duty is much more broadly put. It's a duty to meet needs. And that allows local authorities working with disabled people and carers to be creative in the way that needs are going to be met. And of course, the process of determining how to meet needs is the care and support planning process. And that creativity and flexibility is going to be even more important at the current time when the most obvious ways of meeting needs may simply not be available. Going back to the Act, anything else I particularly wanted to point out at this stage? Charging provisions in Sections 14 to 17, we'll mention those again shortly. And then we have the next steps duties. So this is set out in Section 24 and the provisions of the care and support plan, the requirements of the care and support plan in Section 25. Section 26 defines what a personal budget is, essentially an amount of money that's going to be available to meet needs. And Section 27 provides for reviews. And we then have all the provisions in relation to direct payments in Sections 31, 33. A point I'm going to come on to is the point about whether family members can use whether direct payment recipients can use them to pay family members to provide care, particularly family members living in their own home? And the short answer to that is yes, they can, if the local authority accepts that it's necessary for them to do so. The legal test is whether it's necessary for the direct payment recipient to use the direct payment to buy care from a close family member. And at the current time, of course, you would hope local authorities would take a generous approach to that assessment, because if it is necessary, then it can be used in that way. Another point to flag is the safeguarding obligations, which are very important, in particular Section 42, that creates the duty to make inquiries where adults may be at risk of abuse or neglect. And then also to flag up the transition duties, which we'll see are affected significantly by the Care Act. These are all the duties that require assessments of disabled children, their carers and young carers on transition to adulthood, and very importantly, the provisions in relation to continuity of services in Section 66, which are quite technical. The essence of what they do, all these new duties that were added in by Section 66, is say that there can't be a cliff edge between children and adult social care. So if a child is receiving, the disabled child is receiving social care services as a child, and the adult process isn't completed at the point they turn 18, then those services must continue. And Section 66 is a very important provision as well. We see the requirements in relation to advocacy. So Section 67, the requirement for involvement in assessment and planning in relation to the Care Act. Again, a question I'll deal with is the extent to which this is affected by the Coronavirus Act. Very important provisions that safeguard disabled people's rights to be supported to be involved in decisions that affect them. And another point that is definitely worth noting at the moment is Section 73 of the Care Act, Section 73, which does something, again, quite technical, but here very important. It extends the reach of the Human Rights Act to cover situations where registered care providers are providing care and support to disabled people, either in a place where they're living or in when the residential accommodation is being provided together with nursing or personal care. And where that applies, then that means they are taken to be a public authority and can be challenged for breaching the person's human rights, because otherwise private providers of care and support are not seen as public authorities and do not have to follow the Human Rights Act. So this is very important, and my view is that if it's the case, as it is under this section, that people who are receiving local authority funded care are entitled to challenge providers for breaching their human rights. That must also be the case for people who are receiving health funded care, because otherwise there will be blatant discrimination in a way that I think can't be justified. So that is the whistle-stop tour for about 10 minutes through the key provisions of the Care Act. So one of the things I wanted to do today was show you that you can find the law yourself. So all you have to do to find the Care Act is search for Care Act 2014 and make sure you end up on the legislation.gov.uk website, and that will be the official text, and hopefully it will be up to date. It tells you normally when it was last updated. This is the original version of the Act. And where regulations and so on have been updated, usually the legislation.gov.uk team put the up-to-date version online. So that's a very helpful resource. Second thing I wanted to look at was the regulations in relation to the making of direct payments, just to deal with this particular issue that's already come up repeatedly about whether or not family members can be paid via direct payments. And so this is the regulation to quote. It's Regulation 3, as we see here, of the Care and Support Direct Payments Regulation. And the way the scheme works is that all of the meaty issues under the Care Act are the subject of their own regulations that are called the Care and Support bracket something regulations. And so these are the Care and Support bracket Direct Payments Regulations. And it's the conditions here that the regulations specify must apply when direct payments are being made. So local authorities have no choice. They have to make these conditions. And the condition is, as you see, that they must be made subject to the condition. They're not to use any of the people who are mentioned in the paragraph of the regulations below, which essentially is paragraph 3, all the close family members, except that, and this is the key for our purposes, if the local authority considers it necessary to do so, I can highlight the whole word, necessary to do so, direct payments may be used to pay a person mentioned in paragraph 3 to meet the care needs of the adult, or to provide administrative support. And the statutory guidance says that that's deliberately split, because it may well be more frequently necessary for family members to provide administrative and management support. But here there is a clear provision that allows for direct payments to be used to pay family members to provide care if it's necessary to do so. So that's the regulation, Regulation 3, the Care and Support Direct Payments Regulation. And if that's a point that's concerning you, I wrote a blog for Special Needs Jungle called Care in the Time of Coronavirus, where we go into this in more detail, both for children and adults. So, the next point that I wanted to cover in terms of the existing framework is the National Framework for Adults, NHS Continuing Healthcare and NHS Funded Nursing Care, which, as I mentioned before, is underpinned by regulations. So it's statutory guidance in the way the children's framework isn't, and much clearer in describing an either-or split between the health and social care obligations to disabled adults. Scrolling through, I wanted to go to a couple of points in the executive summary. So we see that the focus here is on whether people have a primary health need, a concept developed by the Secretary of State to assist in determining when the NHS is responsible for providing for all of the individual's assessed health and associated social care needs. And it's very clear, straight right at the beginning, where an individual, this is paragraph 5, where an individual has a primary health need and is therefore eligible for NHS continuing health care, the NHS is responsible for commissioning a care package that meets the individual's health and associated social care needs. Then we get the reference to the regulations, and then we get, coming forward, definitions. And the point I wanted to flag up, where it states even more clearly what the split is where we're looking at the definition of a primary health need. And what's said at the end of this paragraph here is that where an individual has a primary health need and is therefore eligible for NHS continuing health care, the NHS is responsible for providing for all of that individual's assessed health and associated social care needs, including accommodation if that is part of the overall need. So that's the clearest possible statement of the split between social care and health responsibilities. Now, it's important to look, and this is a little bit technical, I'm afraid, but it's going to be very relevant in a minute when we get to the Coronavirus Act, at the regulations that deal with adult continuing healthcare. So this is Regulation 21 of what's often described as the Standing Rules Regulation, the NHS Commissioning Board, so NHS England, and CCG Responsibilities and Standing Rules Regulation. And in Regulation 21, first of all, it tells CCGs and others they've got to comply with the paragraphs below. And then in subparagraph 2, it says that CCGs and others must take reasonable steps to ensure that an assessment of eligibility for NHS continuing healthcare is carried out in respect of a person for which that body has responsibility in all cases where it appears, etc. So you can see there what the test is. It's just simply that there may be a need for such care. So that's the duty to assess for eligibility for NHS continuing healthcare. First of the points to note. Second point to note is, if we go down to 12, that the regulations require that CCGs must have regard to the national framework. So that's what makes the national framework a statutory document in adult care. Both of those provisions are affected by the Coronavirus Act, as we're going to see. So now we get to what is arguably the villain of the piece, certainly in terms of adult social care. Now, the Coronavirus Act is, I would suggest, an extraordinary piece of legislation for extraordinary times. It deals with a huge range of issues where it was felt that the government needed additional powers or needed to be relieved in our case of certain duties in order to meet and to manage the current crisis. So just briefly, in terms of understanding the structure, you'll see that, as usual with acts, it's in sections, and they deal with quite different and discrete points. So the emergency registration of health professionals here at the beginning, temporary registration of social workers, emergency volunteers. There's then modifications in terms of mental health and mental capacity legislation. Now, one of the most important there is that in particular situations, only a single doctor's recommendation will be needed for detention under the Mental Health Act. Now, that's very problematic, I would suggest. Perhaps understandable given the pressure.
Yes, please.
Okay, great. So I was looking at what the Coronavirus Act does in terms of continuing healthcare. And so we see straight away in section 14, subsection 1, that CCGs won't have to comply with the duty to assess. and they won't have to comply with the duty to have regard to the national framework. So there's no longer, and this is now in force, so I should say they don't have to comply. There is no longer an obligation to carry out an assessment of eligibility for continuing healthcare, nor is any obligation to have regard to the national framework, so long as the current crisis continues and the Coronavirus Act remains in force. And so then you see, going through the rest of the section, lots of references to if the relevant body chooses to comply. And so there are powers still to carry out these things, but no obligation to do so. So again, we see here at subsection 5, if an assessment of eligibility is nevertheless carried out, but if they choose to do it, then they must do certain things, take reasonable steps, etc. But there's no obligation to do so. So essentially the duties, the core duties that underpin the continuing healthcare framework have been taken away. So that's section 14. It leaves CCGs with a huge amount of discretion as to how they approach their duties to meet the primary health needs of disabled people with significant levels of need. So that's section 14, dealing with continuing healthcare. We then have section 15 that deals with local authority care and support. And very differently to section 14, we see that all section 15 contains is a reference to schedule 12. But schedule 12 of the Act contains the provision that modifies the powers and duties of local authorities in England and Wales in relation to the provision of care and support. So we now have to go to schedule 12 and see what it contains and what it modifies for our purposes, in England at least, the Care Act scheme. And it's a very similar approach for Wales in relation to the Welsh Act. But to start with, in schedule 12, we see that it modifies the powers and duties of local authorities in England, and it's going to, of course, be amending the Care Act. And so right at the beginning, paragraph 2, the local authority does not have to comply with duties imposed by the assessment provisions. So they don't have a duty to assess anymore. And therefore, they don't have a duty to decide whether the person has eligible needs, because how could they? Because they don't have a duty to assess. And they don't have to carry out any transition assessments, we see here at 3, for young people in transition to adulthood. And importantly at 4, nothing here prevents a local authority from carrying out any assessment or making any determination it considers appropriate in terms of its duties, which we're going to look at in a moment. So they have the power to still carry out all the assessments that we're used to now, but no duty to do so. Then we get the provisions in relation to financial resources. So a local authority doesn't have to carry out an assessment of financial resources, subject to the fact that it can't charge for meeting any needs unless it's done so. Then we have the duties and powers to meet needs for care and support, where perhaps the most mischief is caused. And so section 18, our core duty to meet needs for care and support, is removed in its current form or previous form, and instead there is substituted a requirement that local authorities must meet the adult's needs for care and support if, in particular, the local authority considers that it's necessary to meet those needs for the purpose of avoiding a breach of the Adults Convention rights. So in plain English, that means that the duty on local authorities is downgraded to a duty to avoid human rights breaches. So that if not providing care and support, if not meeting needs, would result in a person's human rights being breached, or results in the local authority considering that they would be breached, then they must provide the care and support. In all other situations, it's a may. They can provide the care and support, but they are not required to do so. And the same approach applies in relation to section 20 of the Act for carers as well. Then we have some relatively technical provisions that deal with fleshing those points out. Charging during the emergency period, this is quite important. So if a local authority decides to meet needs or is required to meet needs under sections 18, etc., to avoid a breach of someone's human rights, and they would have been able to charge and decided not to carry out an assessment during the emergency period, then they can do it later. And they can decide to charge essentially retrospectively. So be careful if someone is getting local authority care and there's no mention of charging, they may well be able to come back under paragraph 10 of the schedule and say that they're going to look retrospectively at whether or not the person should be charged. And then we have the duties in relation to care and support planning. So we've got a disapplication of Section 24, the duty to prepare care and support plans, Section 25, duties relating to plans, and quite a lot of Section 27. We'll look at that briefly in terms of the duties to review and so on. Now, the bits of Section 27 that aren't disapplied, just trying to find the Care Act again, are the powers. So if you look at the wording of Section 27, so Section 27(1) has been disapplied, so that local authorities are no longer required. I should say when this comes into force, because it's not in force yet. Local authorities will not be required to keep under review generally care and support plans and review the plan on a reasonable request. But they still have the power in subsection 2 to revise the care and support plan. And if they are going to revise the care and support plan, they must have regard to the matters that are referred to in section 9.4. We'll look at that in a moment. And importantly, they must involve the adult to whom the plan relates, any carer that adult has, and any person who the adult asks them to involve. So the duty to involve remains in force where the local authority is exercising its power to review the plan. And what that means is that care packages can't be cut without the person, their carer, and anyone else who the person asked to involve or who should be involved being part of that decision-making process. So we mustn't see any cuts by stealth in relation to existing care packages. What does involve mean? Well, it has a fairly broad meaning, but it must be involvement that's appropriate to the situation and the circumstances of the disabled person in a way that is meaningful for them. One of the human rights points that we'll come to in Article 8 of the European Convention is that people have a right under Article 8 to be involved to the extent necessary to protect their interests in decisions that are going to affect their private lives and their family lives. And we'll see what those terms mean in a moment. So the Human Rights Act would require involvement, even if it wasn't fleshed out as it is here on the face of Section 27. So going back to the Coronavirus Act and what it suspends, we also see that local authorities won't have to comply with the duties in relation to continuity of care and support when people move. Probably won't be much of that happening right now, of course. And they don't have to comply with the obligations in relation to hospital discharge, because of course there's anticipated to be a need for very significant volumes of hospital discharge, and so a much more streamlined scheme has been put in place. They don't have to comply in paragraph 15 with the transition duties, so the cliff edge between children's and adult social care is reinstated for the period of the emergency, so it will be possible for, I'm afraid, for children to lose their children's services and not immediately benefit from adult services during the emergency, unless it would breach their human rights. There are some retrospective provisions here. A local authority doesn't have to comply with a relevant duty in relation to duties arising before the day the Act comes into force, if it would apply after that day. See that there. In terms of the period of time in which assessments must be carried out, we know that they have to be carried out in a reasonable period, but local authorities will be allowed to rely on the emergency provisions to say that essentially this period of time should be discounted. And then interestingly, at the end, the Secretary of State may issue guidance about how local authorities to exercise functions under the Care Act, but also under Section 2 and Section 17, Section 2 of the CSDPA and Section 17 of the Children Act in relation to children, interestingly. So it does seem to be that the guidance must be on how to exercise those functions in consequence of the Coronavirus Act, in consequence of the provision made by this part of the schedule. So we shouldn't see general disapplication of the children's scheme through guidance. That would seem to be unlawful. It would only be to the extent to which it touches on, for example, the transition duties. But there will be guidance on the Coronavirus Act for disabled adults in relation to the Care Act, and that should be coming shortly. Local authorities must have regard to any of that guidance. They must comply with it if the Secretary of State directs them to, and they have to disregard any older guidance, even if it's statutory, if it's inconsistent with the Coronavirus Act guidance. So the Coronavirus Act guidance trumps any previous guidance, like the care and support statutory guidance for this period. And then we have very similar provisions in relation to Wales as well, in the amendments to the Social Services and Wellbeing Wales Act. Just one point in Wales that is different, interestingly, is in terms of the duties to meet needs for care and support. The relevant condition is that the local authority considers it necessary, that's the carers one, to meet the carer's needs in order to protect the carer from abuse or neglect, or the risk of abuse or neglect. And that language about protecting people from abuse or neglect, or the risk of it, is reflected in section 35 as well, the duty to meet disabled adults' needs. So that's what the Coronavirus Act shortly, we anticipate, will do. Where does that leave us then in terms of the Care Act and which parts are enforced? Well, as far as I can see, there's no modification to section 1. So local authorities are still required in everything that they do in exercising their functions under the Care Act to promote the individual's well-being. So even if they haven't got a duty to, for example, assess, determine eligibility, engage in care and support planning, they must still decide whether to exercise those powers, which they're effectively becoming, on the basis of a consideration of the need to promote the individual's well-being. And that may well be an argument that disabled people and their advisors need to use in trying to persuade local authorities to exercise powers at this time. So, where does that leave us then in terms of people's rights? Well, the most fundamental right under the Care Act is the right to have your needs, your eligible needs met. And we've seen, and I'll just go back to it because it's so important, that in relation to that duty in section 18 of the Act, what we now have is the requirement that the local authority considers that it's necessary to meet the person's needs for the purposes of avoiding a breach of the Adults Convention right. So it's up to the local authority in the first instance whether they consider that, but of course that decision, and they'll have to take a decision, will be challengeable by way of judicial review if the person or their supporters don't agree. So what human rights are in play? Well, the convention rights, as we see here, have the same meaning as in the Human Rights Act 1998, and those rights are scheduled to the Human Rights Act, and they are most of the rights in the European Convention on Human Rights. So first of all, of course, we have Article 2, the right to life, which itself carries a positive obligation on the state in it. Then we have Article 3. It's headed prohibition of torture, but the description is actually that no one shall be subjected to torture or to inhuman or degrading treatment or punishment. And it's really that inhuman or degrading treatment or punishment that I anticipate people will be relying on and referring to in the course of the debates that will necessarily happen now about whether it's necessary to provide care to avoid a breach of someone's human rights. And a case to flag up is the case of Price in the United Kingdom, from quite an old case now from 2001, where a disabled person was in a police cell and in prison in conditions which she said amounted to inhuman and degrading treatment, and the European Court of Human Rights agreed. And so we see that she was very severely disabled, and male officers have been used to assist her attend the toilet, and she'd been kept in conditions which for her have been dangerously cold, with a risk of developing sores, and left her unable to attend the toilet or keep herself clean. No intention to humiliate, importantly, and the question had to be looked at in the light of her particular circumstances and needs, and the treatment was degrading. So to detain, and it is important that she was detained, of course, a particularly vulnerable position, but to detain a severely disabled person in conditions where she's dangerously cold, risks developing sores because her bed is too hard or unreachable, and is unable to go to the toilet or keep clean without the greatest of difficulty, constitutes degrading treatment contrary to Article 3. So that's the floor. That's the absolute baseline in terms of when care and support will be needed to be provided. And there's quite a lot of case law in the context of people who've got no recourse to public funds and might have care and support needs, where much older legislation has already required them to demonstrate a breach of their human rights, about these kinds of issues in terms of destitution and the bare minimum of provision that Article 3 requires to be made in order to avoid a breach of the Convention. So that is Article 3 and its likely effect in our area. The next article to flag up, briefly at least, is Article 5, where dealing with the right to liberty and security, saying that no one shall be deprived of their liberty, save in the following cases. And the of course, there's provision in E for detention of, for the prevention of spreading of infectious diseases, which may be about to become very relevant. But there's also in that subparagraph provision in relation to persons of unsound mind, and it's from this that we get all of the burgeoning law around deprivation of liberty, the deprivation of liberty safeguards, the Cheshire West case, and so on. But Article 5 does also include positive obligations to avoid deprivations of liberty that are unnecessary. And it may be, and that's a developing area, but it may be that in order to avoid a disabled person experiencing a deprivation of liberty that's unnecessary, care and support may need to be provided. So then probably where the most focus will be in terms of the convention is going to be Article 8, the right to respect for private and family life. And as you see, the article is framed in two parts. So everyone has the right to respect for his private and family life, his home and correspondence, and then there shall be no interference by a public authority with the exercise of the right, except as is in accordance with the law and is necessary in a democratic society in the pursuit of a legitimate aim. So what that's often described as, particularly the words necessary in a democratic society, is a proportionality test, and in particular whether the interference strikes a fair balance between the person's rights and any wider public interest. Now, Article 8 does contain a positive obligation to help people, particularly vulnerable people, secure their secure their right to respect for their private life and their family life. And private life as a concept has been defined quite broadly. So it includes a person's physical and psychological integrity, their well-being, their sense of who they are, their ability to make connections with others, and so on. But in order for there to be a positive obligation under Article 8 to provide care and support, again, the bar is set very high, and that's made clear in a couple of cases that I'll show you briefly. First of all, the case of Bernard, again, an old case now from 2002. The facts are not entirely dissimilar to the facts of Price, but importantly in this case, which was a person in an ordinary accommodation, there was no breach of Article 3. So the claimants were husband and wife with 6 children, and the wife was severely disabled and a wheelchair user, and the local authority failed for a lengthy period to provide the family with suitable accommodation, with what the court described as appalling consequences. The wife was doubly incontinent and was forced to defecate and urinate on the living room floor and couldn't look after her children. And in that case, the court said it came close to, but there was no breach of Article 3, even when it was that bad. But there was a clear breach of Article 8, and the court made a significant award of damages to recognise that breach. But Bernard was cited, of course, in McDonald, which was a case that I was involved in, which was a case that went to the Supreme Court and involved a former prima ballerina of the Royal Scottish Ballet, who had a condition requiring urination at night, but she was not incontinent of urine, and she had been receiving a carer who was able to support her at night to use the commode. The local authority decided to withdraw that care and provide incontinence pads instead, and the challenge failed on all the grounds, including a ground of challenge based on Article 8. So the Supreme Court held that there was no breach of Article 8 and no breach of the positive duty to provide support to Mrs. McDonald in refusing to provide her with a carer and instead only providing her with incontinence pads. Now that case then went to Strasbourg, to the European Court of Human Rights, and the European Court did find a breach of Article 8, but only in relation to the period in which the local authority hadn't carried out a proper assessment. So it was, in a way, just a technical breach. And as the duty to assess has just been taken away, that may cause difficulties. Although, of course, as we've seen, the duty to involve disabled people in any review of their care and support plan is still in force and will still be in force when the Coronavirus Act itself comes into force. The most recent words I think that I've seen in relation to Article 8 and the provision of care is this case, a case called MIV and London Borough of Newham from 2018. And I've written this case up for the Council for Disabled Children, as you see here. So if you search CDC case law updates, you'll get the full list of updates. And if you put MIV and Newham in MIV v Newham, then you'll get this one in particular that comes up. And we see from the overview that this case was about a 5-year-old child who had and family had no leave to remain in the UK, couldn't access mainstream social housing or benefits. And the issue was whether or not the accommodation that had been provided to them was suitable for the child's needs. And the argument was that the impact on the child of being housed in unsuitable accommodation was of such severity that it breached Article 8. And the problem for the claimants was the judge, having looked at the previous case law quite extensively, including an important judgment of the Court of Appeal in a case called Anna Frigieva, found that in terms of your private life, your rights to, for example, physical and psychological integrity, unless you at least engaged Article 3, unless you were very close to a breach of the right to be free from inhuman and degrading treatment, it was very unlikely there would be a breach of Article 8. But if the right in issue is the right to family life, there may be a positive obligation under Article 8 to provide welfare support. So it's easier to establish the duty to provide support if what you're arguing is that failing to provide that support will effectively destroy family life for a family unit, than it is for a disabled adult, for example, who lives on their own, to say that they need support to avoid a breach of their Article 8 rights to their own well-being, their own physical and psychological integrity. And it made no difference that the person was particularly vulnerable by reason of disability, although that will be a relevant factor in terms of whether Article 3 is engaged. And there's the reference to Bernard, where there wasn't a breach of Article 3. And very importantly, I suggest, the judge in this case found that there were 3 requirements for there to be a breach of Article 8 set out here. And the first of them is there had been a failure to provide the claimant with some form of benefit or advantage to which they were entitled as a matter of public law. So there had been a breach of duty by the local authority to provide a benefit or advantage. And of course, the problem that we'll now have is that the Coronavirus Act is taking almost all of those duties away. So people won't be entitled as a matter of public law to have their needs met under the Care Act unless it would breach their human rights. That's entirely circular, and it may be the courts have to modify that requirement in the light of the Coronavirus Act, or it may be that it means that actually it's extremely difficult to ever show that there's a breach of Article 8 in the non-provision of care. And even if you can show that, there then has to be grounds for criticising the local authority's failure to act, an element of culpability, and you have to show a serious and substantial impact on the private or family life of the breach of duty. And in that context, it's perhaps unsurprising that this claim in MIB failed on its own facts as well. So it's not, I'm afraid, a particularly happy picture in terms of the protections of the Human Rights Act in the provision of care and support. It does operate as a flaw. It does stop local authorities from refusing to provide care if the person would be left entirely destitute or would suffer inhuman and degrading treatment. And there may be additional obligations to provide support, care and support to avoid a breach of their Article 8 rights, particularly when Article 8 and indeed the whole of the European Convention is read with the other rights in the Disability Convention and the Children's Convention from the United Nations, if appropriate. And that's a growing area of interest for the lawyers working in this area. Those UN conventions, of course, are not incorporated into English law, but can be relied on to inform the understanding of what the European Convention rights require. So that's something that holds some promise. But unless the courts are willing to take a more generous approach to what the European Convention offers in terms of rights protection in the provision of social care and support, I'm afraid that the picture is not looking particularly promising. And that does mean that local authorities will be required to exercise their powers, or will be asked to exercise their powers to essentially do the right thing without having the legal duties that disabled people are used to being able to enforce. And so that will require, for example, close consideration to the new ethical framework that has been published for the provision of social care in this time of crisis, and local authorities and social workers making good ethical decisions about how scarce resources can be allocated, even where they haven't got the clear duties to provide that we're used to. And just finally, before we move on to questions, I wanted to flag up the Equality Act as well, which isn't taken away or modified by the Coronavirus Act. And we'll look at the public sector equality duty in a moment. But I wanted to flag, of course, disability as a protected characteristic under Section 6 of the Equality Act. We can see the broad definition of disability in subsection 6.1, and that there's a whole list of prohibited conduct under the Equality Act. First of all, to flag up indirect discrimination under Section 19, where you have a general policy or a provision, criteria or practice, as the Act refers to, which applies to people generally, but which puts disabled people here at a particular disadvantage and which can't be justified as a proportionate means of achieving a legitimate aim. So that's one ground of challenge under the Equality Act, that something that's being done to the population generally disproportionately impacts on disabled people in a way that can't be justified. And also, very importantly, of course, specifically for disabled people, we have the duty to make reasonable adjustments. And you can see that the duty is in three parts. It applies generally. There are some technical tweaks to this in different areas of life to, again, policies, provision, criteria, or practices. It applies to physical features, and it applies to the provision of auxiliary aids, and that can include people, importantly. So a support worker could be an auxiliary aid that would have to be provided by way of a reasonable adjustment under Section 20, subsection 5 of the Equality Act, if in all the circumstances it's reasonable to do so, because you can see that for each of these requirements, it's a requirement to take such steps as is reasonable to have to take to avoid the disadvantage. And then the public sector equality duty, which is one of the most litigated parts of the Equality Act in Section 149, again, not altered by the Coronavirus Act, is a duty on all public authorities, including local authorities, to have due regard to a series of needs, including the need to eliminate discrimination, the need to advance equality of opportunity, and the need to foster good relations between here disabled people and non-disabled people. And having due regard to the need to advance equality of opportunity involves having regard in particular to the need to remove or minimise disadvantages suffered by disabled people, to take steps to meet disabled people's needs, and to encourage their participation in public life. And taking steps to meet the needs of disabled people includes taking steps to take account of their disabilities. So there are some very particular obligations on local authorities in terms of when they're making decisions about how to exercise their powers, they will have to have due regard to all of these needs. In particular, I suggest the need to advance equality of opportunity between disabled people and others, given that disabled people are likely to be experiencing this pandemic as even more disruptive and dangerous than the general population. So that was what I wanted to say about the core issues around care and support. I did, though, want to, before we move on to questions, touch on one other thing that I'm going to have to quickly look up, which is an issue that's been hugely controversial, which are the NICE guidelines on critical care. And people may have seen that NICE, the National Institute for Health and Care Excellence, published guidelines on critical care, which certainly, to my reading of them, risked having disabled people with high levels of care need assessed very high on what's described as the clinical frailty score, the CFS, and therefore perhaps being deprioritised for treatment in the event that they were admitted to hospital. And NICE have listened, as they say, to those concerns and amended the guidelines. And there's a descriptor here that you can see as to what the process was and what they updated the guidelines to say. But if we look at the actual wording of the guidelines themselves now, instead of applying this CFS score, which was developed, as I understand it, for older people, what we now have in Section 1 of the guidelines is a requirement, if a person is admitted to hospital, to assess them for frailty. The CFS, the clinical frailty scale, should be used as part of that assessment, but aware of the limitations of using it as the sole assessment of frailty, and it should not be used, very clearly now, it should not be used in younger people, people with stable long-term disabilities, for example, cerebral palsy, learning disabilities, or autism. An individualised assessment is recommended in all cases where the CFS is not appropriate. So instead of using this scale, which risked younger people and disabled adults being scored very highly, there's instead supposed to be an individualised assessment, which would obviously focus on the particular needs of that person. And that seems to me to be a significant improvement. Not that the risk of discriminatory treatment in intensive care settings has completely gone away, but it does seem to have been reduced by the change that's been made here to the NICE guidelines. So with that in mind, Julie, I'll hand back for any questions.
Thank you. Do you want to shift the presenter back to me, because I've put
yes.
PowerPoint.
Let's see if I can do that. I managed to reduce lots of things, so I'll have to. Yes, change presenter. There we go. I think you're back on, Julie.
Yeah, that's great. So from a lot of the questions that have come through live, there's a lot of questions about the actual activation of the bill.
Yeah.
So people are asking, to be activated, does it have to go to the Secretary of State first? How's it done? Is it enforced now?
Sure, I can take that quite quickly. It's complicated. So some of the provisions came into force the moment that the Act was passed, and that includes, just to remind people, Section 14 in terms of continuing healthcare. So this, oh, you're not seeing my screen anymore. So the provisions of Section 14, which deal with continuing CHC assessments and regard to the national framework, are immediately enforced. They're enforced now. The Care Act changes in the schedule will come into force by regulation, and as far as I can see, we don't know when those regulations are going to be laid. The Secretary of State has said that they will only come in at the appropriate time. I do, however, understand, thanks to Jess Flanagan, that the Welsh amendments are enforced from the 1st of April, but I haven't seen anything that says that the English amendments are enforced then, but it's probably going to be imminent. I think that's all we can say. Just one other thing to mention that will concern some people on the webinar, the changes to the scheme in terms of special educational needs and disability in the Children and Families Act, they come into force when the Secretary of State makes a notice. And before he does that, he's got to form a view that it's appropriate and proportionate to make that notice and give the reasons in the notice. So there's yet another mechanism there for a different part of the Act coming into force.
Just staying on that theme, Steve, these things about who would the local authority or the CCG be accountable when making them decisions to switch on the activation, and when would it be switched on? Would it stay switched on for 2 years, or would they do it on a month review?
Well, of course, the activation is national, so the individual local authority and CCG aren't accountable. Their duties in terms of the local authority are immediately downgraded to powers, in essence. They are then accountable for how they choose to exercise those powers locally. They're accountable to their local community. They're accountable to local groups and campaigners. Ultimately, they would be accountable to the Ombudsman, but of course we know that the local government Ombudsman has suspended dealing with all complaints at the moment. And yes, those powers, the changes in the law will remain in force until such time as either the regulations are revoked or the Secretary of State removes the notice in terms of send, or the Section 14 is repealed in terms of the CHC scheme. There is now a 6-month review, and so it may well be that they're not in force even for that long, of course, because if the Secretary of State decides that the crisis is dealt with sufficiently and we can return back to the previous scheme, then that's what's expected to happen. But there is a risk that that the changes will be significant and long term. Thanks.
Are you okay to stay on for another 5 minutes?
Yeah, I'll stay on for another 10 minutes, given we lost a lot of time with the audio issues. So yeah, sure.
So another very, very common one is, would this bill allow local authorities or CCGs to cut existing care packages that have been in situ for some time?
I fear the answer to that is potentially yes. So of course, we've seen in terms of Section 27 of the Care Act that the requirement to involve people in reviews of care and support plans and packages remains. But that doesn't stop ultimately the local authority deciding that in the current crisis, they can no longer provide that package. And the real safeguard in the statutory scheme was always Section 18 of the Care Act and its equivalent duties elsewhere, saying you must meet needs. And Parliament has decided to take that away for the existing period. So I'm afraid there is a risk of cuts. It seems to me, at least, and this is all very new and we're trying to work it out, but it seems to me there is a risk of cuts to existing packages. Local authorities essentially are being told you will have available resources in your area and you're going to have to prioritise how to spend them. And so the absolute entitlements to have eligible needs met are taken away. And people who find themselves in that situation, obviously we hope that isn't what happens. We hope local authorities choose to exercise their powers in a way that means that existing packages stay. But if they are not, and if people are told your care package is going to reduce in some way, then they'll need to get advice. And one thing I haven't mentioned yet is that on my blog, there is a list of solicitors, not all of them, of course, but some solicitors who work in this area. And if you search rights in reality solicitors, you'll get that list, and hopefully people will be able to access advice as to whether or not these decisions can be challenged.
And then there's a whole ream of question about how this affects people on Section 117. So there's a number of questions that are saying, my child or my relatives on a Section 117, and yeah, I'm not being able to see them face to face. Is there anything I can do about that?
Sure. Well, first of all, Section 117 is not a section of the Care Act, of course, a section of the Mental Health Act. And I don't think that the Coronavirus Act does anything about the aftercare duty. But having said that, I'm just going to check quickly. So for those who don't know, it's the duty to provide aftercare services for people who have been subject to detention under the Mental Health Act. And it's a joint duty placed on local authorities and CCGs, and they must provide that care free of charge. And I'm just looking at the mental health provisions, which are in Schedule 8. And we see, for example, paragraph 3 as we go by is the single recommendation point that's caused lots of concern. So you can now support an application for admission to hospital to a single recommendation from the doctor. I'm just going to see, sorry, of course you can't see this because you're not seeing my screen, apologies. I'm just looking through Section 117, through the schedule to the Coronavirus Act, and at the moment I can't see any amendment to Section 117. So in terms of the duty to meet
it might just be that it's about infection control that's sort of keeping people away.
Yeah, so that's a slightly different issue. So let me answer that one. So, and that obviously would apply across the board. You've got people in a particular care setting and the provider is saying no visits because of infection control. Well, obviously, infection control at this time is a legitimate aim. It may well be appropriate to heavily restrict visits, and in some situations it may be appropriate to ban them. But I would be very concerned about blanket bans on all visits to all people in all situations, because in some cases the risk of that person catching coronavirus is significantly outweighed by the detriment that's going to be caused to their physical and mental well-being by not being able to see anybody. And so there has to be a best interest decision if the person lacks capacity, a decision that is proportionate, because clearly restricting visits is a significant interference with people's Article 8 rights to family life and to private life. And there has to be proper consideration of what the impact will be. But if there is a risk that visitors will bring the virus into a care home or another setting and infect a large number of vulnerable people, you can see that even with significant detriment being caused, a ban may be appropriate. So I just would urge providers and public bodies to be considered in their approach to this, not rush into blanket bans, but think about what's the least restrictive measures that we can take that would properly safeguard us and our residents and service users in terms of the virus, but without unnecessarily destroying people's rights to family and private life.
Thanks. Gaynor, do you want to do a few from what have been sent in previously on email if Steve's not already covered them?
Yeah, sure. There's one I think that's not been covered. This is from someone whose their son is leaving alternative provision to take up mainstream place in September, and they've asked for an EHCP, an Education Healthcare Plan. This will be his first plan and he's 18. Will there be an application? Will an application be processed currently? And if so, how long will it take?
Yes, well, that's a very good question. So this is where the real detriment is caused by the removal of the transition duties in terms of moving from children's social care to adult social care, also removing the assessment duty for new entrants to adult social care as well. So the local authority in a situation like this, obviously I can't advise on any individual cases here, but in that kind of situation, the local authority will have a power to assess in terms of adult care provision, but no duty to do so. Unless it would breach, well, no, actually the assessment duty is not even explicitly affected by the person's human rights, although Section 6 of the Human Rights Act says that at all times local authorities must comply with people's human rights. So that argument might still be there, but otherwise there's no duty to carry out the assessment. The EHC plan, if they have one, and if that's going to continue post-18, that duty to maintain the plan continues, but the duty to secure the provision in it and to arrange the healthcare provision is liable to be modified into a duty to use reasonable endeavours. which is a much weaker duty than we currently have, and that will take place once the Secretary of State issues the notice that I was mentioning beforehand. There's also not going to be, for the period of the crisis, a duty to admit people into settings that are named in Section I of their plan. So it's all rather unclear. It depends what has been brought into force when, and families in that difficult position of finding themselves with a transition, an important transition to deal with at this time, are almost certainly going to need individual advice, either from a lawyer or from organisations like EHC or other voluntary sector groups, because the position is literally evolving day by day at the moment.
Okay, thank you. And this one has been covered, but I suppose just to reiterate it, someone, if they have a son with autism and epilepsy, and also sometimes has behaviour that challenges when they're anxious, and they're just concerned that what are their rights as parents, and also residential care support teams to support people if they end up in hospital.
Absolutely. So that's very similar to the answer I was giving in terms of care provision generally. So many hospitals will of course want to restrict visiting, may even prohibit visiting. But if you've got a situation where a young person or an older adult is extremely vulnerable and will really struggle and suffer without their family member or other person with them, and that person's willing and able to come to hospital and appears to be virus-free, although of course who knows, the hospital will have to make a decision as to whether or not it's appropriate to let them come, and we'll have to consider all the circumstances. We'll have to take into account their reasonable adjustments duty under the Equality Act, which also applies to private providers of care generally. And a hospital, as a public authority, will have to consider the person's human rights as well. But at the end of the day, if there's good reasons and real concern in terms of the spread of the virus, they may still take a decision that is negative in terms of the disabled person and their family. And in that situation, it may be very difficult to challenge because, of course, it will be an emergency situation. But families may still be able to get advice depending on what's happening, and may need to challenge that decision. So I'm afraid I can't give an easy answer to that. What I can say, though, is that blanket policies and rules that exclude family members or that otherwise disadvantage disabled people, and where there's no evidence of any real consideration of the impact of that, are potentially challengeable.
Okay, thank you. I've got one other, but I think you've really gone over it on the nice.
No, it's okay.
Okay.
I don't mind taking one more.
Okay.
That's fine,
So, so someone that's concerned about the point about eating disorders, as it's the first time that they've seen people with low body weight has been at risk, and many people with autism and children, young people, have limited eating habits, which may impact on their body weight. And is this something that's likely to affect the 0 to 9 fragility scale ratings for under the coronavirus bill?
Absolutely. So that takes us back to the NICE guidelines that I mentioned a moment before. And of course, the key point to bear in mind, and you may even need to have this to hand, this wording to hand, is that the CFS, the frailty scale, should not be used in younger people, people with stable long-term disabilities, for example, cerebral palsy, learning disabilities, or autism. So they shouldn't be assessing, intensive care settings or hospitals generally, should not be assessing people with learning disabilities or autism against the CFS, which is at the link here, which was designed, as I say, for use with older people. What they should instead be doing, or at least is recommended that they do, is an individualised assessment, which would take account, of course, of the impact for them of receiving intensive care. But that would have to be based on the assessment of that individual's needs and their presentation, not based on any kind of discriminatory assumptions about people with particular diagnoses or conditions.
Okay, lovely. Not sure, Julie, do you have some more from the panel?
I'll take a couple more if you've got them, Julie.
There's some sort of, one is around if the PAs or the current provider is no longer able to provide services to a person, would then that support just fall on the family, or do the council or the CCG have a duty to provide at least some core service?
Well, at the moment, as in today, the Care Act would require the local authority to ensure that the eligible needs were met, but that's the duty that we anticipate will be taken away very shortly. And so it may be that unless it would breach the person's human rights, the local authority would only have a power to secure alternative care, and they may or may not decide to exercise that power. And so it may fall on the family, but that's where we get to the situation where possibly direct payments could be used to pay the family members to provide the care instead. I should have flagged earlier when I was talking about that there are employment law considerations in relation to that. If you are employing a team of PAs already, obviously you can't just immediately withdraw that funding and transfer it to a family member. It's not an area that I'm particularly expert in, but I understand there's another webinar on Wednesday, Julie, where those issues hopefully will be canvassed. But it is going to be important to anyone who's thinking about switching their care from employed PAs to a family member who'd be providing the care, to think about what that would mean for their obligations as an employer, and to take advice about that if they need it.
That's great. Thank you ever so much for your time, Steve. I'm realising that we're nearly 15 minutes over now.
No problem at all. I hope it's been helpful, Steve. And I really wish everyone the best with trying to grapple with this very difficult situation that we find ourselves in, not just in terms of the virus and what it's doing to people's day-to-day lives, but also with a very significant change to the legal framework that's gone through incredibly quickly, and which us lawyers are all trying to get our heads around, and which does have really serious implications for disabled people's rights, in my view. But hopefully, local authorities will continue to do the right thing, and social workers will continue to act under the ethical principles. And there's certainly an important point to end on, perhaps, is there's certainly no legal barrier to the provision of care, the ongoing provision of appropriate care and support for disabled children and adults. What we've lost, though, at least for now, it seems, when this part of the Act is in force, we've lost the duties that make those things happen, and that's very worrying. And it does therefore leave an awful lot in the laps of very hard-pressed local authorities who are going to have to try and work out how to exercise their powers appropriately at this time.
Thanks, Steve. And I would encourage people to look at that ethical guidance. You'll find it on the Be Human link, and people have asked about the solicitors list Stephen mentioned, so we'll ask Steve if we can kindly put a link to that on there as well.
Yeah, that's fine, Julie.
So thank you very much. Thank you for joining the webinar. Take care, and there's another webinar on Wednesday that's directly around employment issues. And if people want to suggest anything else that would be useful, please get in touch with us. Take care.
Thanks, everyone.
Thank you.